Can't see the video. Oh, wow. Hello, everybody. Hopefully you can see me. This is JayKaplan. I'm the staff attorney for the ACLU of Michigan's LGBT project, and we're going to get started in just a couple of seconds. Okay. All right, welcome everybody. Again, my name is JayKaplan, and I'm the staff attorney for the ACLU of Michigan's LGBT project. And thank you for joining me this evening. I wanted everybody to know that during this unsettling and sometimes scary time, that the ACLU of Michigan is busy and at work and available for you to help address issues involving civil liberties and civil rights. And I think it's also important, tonight I'm going to be talking about transgender issues, but also to recognize that there's a great deal of intersectionality in the work that we do. So in other words, our legal staff is advocating for prison and jail release policies on behalf of inmates who are either in pretrial detention, who have health risks concerned with the virus to be released. We are working to, in terms of the immigration detention centers, to have people released from there, and advocating for ICE not to be making arrests during this period. We're also working to ensure that people don't have utility shutoffs during this crisis, as well as to help individuals with regarding eviction actions. In addition, which of course impacts the transgender community as well. And in addition, the LGBT project is still available to assist people, members of the LGBT community, who are experiencing discrimination and issues related to their sexual orientation and their gender identity. So I want to make sure that people have my email address. It's Kaplan, Kaplan, at aclumich.org. And my phone number is 313-578-6812, and you can leave a message and I will get back to you. You can send an email and I will get back to you. So I wanted to first provide you with some updates regarding important litigation and policies impacting the transgender community. And then I wanted to leave some time, of course, to answer any questions that people might have. So the first, probably the most important thing that we are all waiting for is a decision by the United States Supreme Court in two LGBT-related cases. The first case, Zarda and Bostic, it involves gay men who were fired from their jobs for being gay. And in the second case, which is actually the ACLU of Michigan's case, EEOC versus Harris, involves Amy Stevens, a transgender woman who was fired from her job at a funeral home for being transgender. And the issue in both these cases before the United States Supreme Court is whether or not federal civil rights laws that prohibit sex discrimination, does that cover LGBT people who've been discriminated against? Is this discrimination because of sex? And we've seen many federal courts decide that yes, that this is a form of discrimination based on sex. So in the case of transgender people, in the case of Amy Stevens, she was discriminated in her job. She was fired in her job for being a transgender woman. And it was because of gender stereotypes related to the gender that was assigned to her at birth, which resulted in her discrimination. Why is this theory of sex discrimination so important for LGBT people? Well, that's because only 21 states have civil rights laws that explicitly mention sexual orientation and gender identity. Michigan is not one of those 21 states. We're one of the 29 that don't have those explicit mentions, and therefore we have to rely on court interpretations regarding this theory of sex discrimination. Also, our federal civil rights laws don't explicitly mention the categories of sexual orientation and gender identity. So these are very important decisions from the United States Supreme Court. Amy's case was argued, and the other case were argued back in October. And we can expect a decision anytime, although the next time the Supreme Court is due to issue some opinions is April 20th. In the best scenario, the court will agree with what the other federal courts have done, the lower federal courts have done, and they will find that there is that this is a form of sex discrimination and there is protection under current federal civil rights laws. But even in the best scenario, we still want to make sure that in our federal and our state civil rights laws that we have these explicit mentions of sexual orientation and gender identity, so we don't have to rely on the courts to make those interpretations. In the event that the court doesn't agree with what the lower federal courts have held, then we really have to continue to advocate, particularly in Michigan, for our Michigan legislature to amend our current civil rights laws to explicitly mention sexual orientation and gender identity. And we also have to advocate in our state courts that they find that discrimination against transgender people is a form of sex discrimination. I should also mention that in Michigan, in May of 2018, the Michigan Civil Rights Commission, they issued an interpretive statement saying that Michigan civil rights laws protect LGBT people from discrimination under the theory of sex discrimination. Now, this is an interpretive statement. It's not a court order. It's not a court interpretation of the law. But as a result of that interpretive statement, since May of 2018, transgender people who've been discriminated against in Michigan in the areas of employment, and housing, and education, as well as public accommodations, they can file a civil rights complaint with the Michigan Department of Civil Rights. So that's a very important remedy that we currently have. However, that's under attack with a lawsuit that was recently filed. It's called Roush World versus the Michigan Department of Civil Rights. Roush World is an entity that rents out their property for weddings, but they refuse to rent out their property for same-sex couples who are getting married. And a civil rights complaint was filed against them, and then they, in response, filed a lawsuit challenging the authority of the Michigan Department of Civil Rights to investigate LGBT discrimination complaints. And so we're going to have to see where this goes. It was filed in the Michigan Court of Claims, and eventually, I think the ACLU is going to want to get involved in filing what's called an amicus brief in support of the Michigan Department of Civil Rights. Another important case to providing anti-discrimination protections for transgender people is a case called People of the State of Michigan versus Rogers. And it's actually not a civil rights case. It's a case involving Michigan's Ethnic Intimidation Act, which is our hate crimes law. And in that particular case, a transgender woman in Detroit, she was shot in the shoulder at a gas station when her attacker discovered that she was a transgender woman. And so the Wayne County prosecuting attorney brought charges against this individual, and also brought charges under Michigan's hate crimes law under the category of gender. And on appeal, the defendant argued that the Michigan's hate crimes law was never intended to cover transgender people under this category of gender. And unfortunately, the Michigan Court of Appeals, in a published decision, the majority agreed with the defendant. And they said that the definition of gender in this particular statute only pertains to one's biological sex, or the sex that was assigned to the person at birth, and therefore transgender people couldn't be protected under this law. Not only was that a disturbing result for this particular situation, but we're concerned that this type of argument, this type of analysis which we believe is very flawed by the Michigan Court of Appeals, will be used by other people to argue that transgender people are not protected under civil rights laws. And so we are planning also to file an amicus brief, which is a friend of the court brief in support of the interpretation that laws that pertain to sex and gender cover transgender people. So those are pretty significant cases, and we're going to probably see more litigation happening in our state courts, as well as more advocacy efforts to try to get our legislature to amend our civil rights laws. Legislation has been introduced numerous times to explicitly mention sexual orientation and gender identity, including this particular Michigan legislative session. The problem has been is that the legislative leadership, the House leader and the Senate leader, have refused to move the bill forward. With the Federal Equality Act, which would be a federal civil rights law that explicitly mentions gender identity and sexual orientation, it passed out of the House of Representatives, but the Senate leader, Mitch McConnell, has refused to take it up in the Senate. And President Trump has indicated on previous occasions that if it passed the Senate, that he would veto such legislation. So we have to continue our advocacy efforts to make sure that we have these explicit protections. I also wanted to address some incidents in the recent media regarding bills that have been introduced in various state legislatures, which are clearly an attack on the transgender community. And some of you might have heard that just this week in Idaho, their governor, Brad Little, signed into law 2 pieces of legislation that clearly discriminate against transgender people. The first bill is a bill that would prohibit transgender students from being able to participate in high school sports as well as college athletics in accordance with their gender identity. And then the second bill would prohibit transgender people from being able to get gender marker changes on their birth certificates. You know, it's ironic that in this crisis that we're in, and despite all the government shutdowns, that the Idaho legislature put a priority on passing what can only be seen as mean-spirited legislation attacking the transgender community, and that the governor decided to sign this into law. But make no mistake, as to both pieces of legislation, we clearly believe that they're unconstitutional by having the government single out transgender youth for discriminatory treatment and denying them the ability to be able to participate as their authentic self in high school athletics or college athletics is clearly unconstitutional. And the national ACLU is already planning on filing a lawsuit against the state of Idaho for this law. And then the second piece, the second law that passed, there was a lawsuit in Idaho, which in the past just administratively would not let transgender people get a gender marker change on their birth certificate. And it was found by the federal court to be unconstitutional, this informal policy. So clearly the law would also be unconstitutional. And it's also ironic that the Attorney General for the state of Idaho advised Idaho's legislature, as well as the governor, that both these laws are unconstitutional. And so I'm sure there will be litigation. Actually, the court decision about the birth certificate, it came out 2 years ago, and they entered what's called an injunction against the state of Idaho for refusing to provide the gender marker change on a birth certificate. And so actually, the state of Idaho would have to get permission from the court to dissolve the injunction in order to implement this law. And I don't think they're going to be able to do so. But I know there's a lot of concerns about this. What we've seen probably in the past year or so, we've seen a new tack by opponents of LGBT rights. And clearly, it's been focusing on the transgender community. And one of the newest attacks is focusing on transgender use. So in addition to what happened in Idaho, we've seen a number of bills that would make it sometimes criminal for doctors to provide hormone therapy to transgender youth. sometimes charges that could be brought against parents who are providing for, who are agreeing and consenting to transitional care for their children who are transgender. We've seen similar legislation with regarding transgender people being able to play in sports. And I think this is just a tactic once again, by opponents to try to roll back some of the progress that has been made on LGBT rights in America. And it was really interesting a year ago when the House of Representatives, the U.S. House of Representatives, they were holding hearings on the Equality Act. And there was going to be an opportunity for opponents to speak out against this legislation. And we fully expected we would see opponents talk about, transgender people and restrooms and, just the myths and untruths and the demonizing of transgender people with regarding facilities use. But what we saw was testimony talking about the problem of transgender athletes, and that somehow this is unfair competition. And this was one of the first times we saw that issue being raised at this particular hearing. And then at Amy Stevens' Supreme Court hearing, now remember, Amy Stevens, her case involves employment discrimination. She worked as an embalmer at a funeral home, essentially. And during the arguments before the Supreme Court, Justice Alito raised the issue about sports, high school sports, which really had nothing to do with the issue at hand. And we made it clear that that was not the issue. But this type of argument is being advanced more and more. Now, I can say on a positive note, in our state of Michigan, it's highly unlikely. Well, first of all, no such legislation has been introduced in Michigan's legislature at this point in time. And should it ever move forward, should it even pass in Michigan's legislature, it's very obviously that the Governor Whitmer would veto such legislation. So we're in the clear at this point in time. But should there be any attempts to introduce this legislation trying to attack trans youth or essential medical treatment for transgender people, you can assure that we will be there, and many members of the LGBT community will be there to advocate against this sort of thing. The other thing that I wanted to bring up as a result of COVID-19, and we've seen, a lot of administrative orders, including orders in our court shutting down non-essential cases, which has an impact on the transgender community, certainly transgender people who have filed petitions for legal name changes, finding that their court dates, their hearings have been postponed. And then outside of the court arena, individuals who've been waiting for their surgery, their gender affirming surgery to be scheduled, only to find that being postponed, or if they were waiting to start on hormone therapy, also seeing that postponed. And the governor's executive order talks about essential medical services, but really leaves that to the discretion of medical professionals about what is medically essential. And I think it's just important to mention, probably most in this audience understands this, is that gender affirming surgeries for transgender people are not cosmetic. They're not necessarily elective surgeries. They're medically essential surgeries to treat the problems associated with gender dysphoria and the pain, both physical and psychological, that people have experienced going so many years without being able to access the surgery or these forms of medical treatment, having to fight their insurance companies for coverage over the years. And then, in Michigan, really the main place where surgery is available is through the University of Michigan. So we really have only one entity, and it takes a long time. There's a long wait list to be scheduled for the surgeries. And so we're now finding folks in, particular difficult situation, which can result in depression and certainly anxiety and hopefully not, but suicidal ideation. And so we are looking into things possibly, to see if there can be some kind of court solution with regards to hearings, that maybe there could be a more streamlined approach with name change petitions that have already been filed with the courts. And of course, we would love to hear, we want to hear from individuals if they found that their surgery has been postponed or they're not able to access their hormone therapy program. There might be some ways that we can advocate so people are able to access those essential medical services that they need. And then another real important issue that is impacting LGBT rights, and of course transgender rights as well, is that of the challenge of policies that are supportive of transgender people being legally challenged as violating the religious freedom or the rights of others who would oppose that. So let me give you an example. There's been some litigation, not in Michigan, but in other states, against schools districts that have a policy allowing transgender students to access restrooms and locker rooms in accordance with their gender identity. And they've been challenged as violating those who would disagree their religious rights. And what we've seen pretty uniformly is that the federal courts have been deciding that no, this is not a violation of someone else's religious freedom. That many times what these school districts do is they do allow transgender student to access restrooms in accordance with gender identity, but they also offer an alternative to any student who is not comfortable using a communal restroom to be able to maybe use a single user restroom. And so there are things in place to address privacy concerns of any student, including transgender students. And there was a case, a federal case involving such a school district, and they petitioned for a writ of certiorari with the United States Supreme Court. In other words, they asked the United States Supreme Court to take up this case. And you need 4 out of the 9 justices to agree to want to hear this case. And they couldn't get those 4 votes. And so that case law stands, and it's a Circuit Court of Appeals decision. But I think we're probably going to see more attempts to try to challenge support of LGBT policies in the name of religion. Actually, in the state of Michigan, we don't have litigation specifically focusing on bathroom policies, but we do have a lawsuit against the Williamston Public School District, which is on the western side of the state, which the school board passed a non-discrimination policy that specifically included sexual orientation and gender identity. In other words, it said that LGBT students are entitled to the same fairness and dignity as other students. And a group of parents then sued the school district, saying that such a policy violated their religious freedom. That, in other words, their religious principles teaches them or tells them that to be LGBT is wrong, and by having a policy like that interferes with their ability to instill such values to their children. The ACLU of Michigan, we were able to intervene in this lawsuit. In other words, to join this lawsuit on behalf of the Gay Straight Alliance at the high school. And we're hoping that this case will be dismissed because clearly, the Constitution protects religious freedom. People are entitled to their religious beliefs, but they're not entitled to necessarily veto a policy that treats other people fairly because they feel it might contradict with what their religious beliefs happen to be. I'm trying to think of any other litigation that's happening right now. Well, back to the sports, the sports situation with transgender youth. Recently, there was a federal lawsuit filed in Connecticut, and it was challenging Connecticut school district's policy of allowing transgender high school track members to compete so these are transgender female students competing on the female track team. And the National ACLU is trying to intervene in this case. But also the Trump administration has filed a statement of interest in this case on behalf against transgender students on behalf of the students who filed the lawsuit, saying that transgender students can't participate in high school sports unless what was assigned to them at birth matches the gender that they want to participate on. So we're going to be waiting to see what happens with that. I had somebody ask me, what about the Michigan Civil Rights Act? I mentioned that legislation has been introduced. What about the efforts to try to put this matter on the ballot, to do a ballot initiative? The ACLU, we're not directly involved with this. We certainly agree with the goal of amending our civil rights laws to explicitly mention sexual orientation and gender identity. We think the legislature could act upon that now. They have the tools to do that. But the ballot initiative is an effort. So if a number of requisite signatures are collected, then it goes to the legislature and they can just decide to pass based on the petition to make that a law. Or if they decide to not to do that, then it goes to the ballot, and it would have to be voted by voters in the November 2020 election. And of course, now with the shutdown and the prohibition on public gatherings because of the virus, it makes it more challenging to collect those signatures. I believe that they're trying to do so by mail. And as I said before, we certainly share that same goal about getting these explicit protections. We think the inaction of the legislature, shouldn't cause people to have to use, tremendous amount of resources to try to make this, to put this on the ballot, and shouldn't result in cost of millions of dollars when our legislature should just do what they're supposed to be doing. And I also wanted to mention, regarding the issue of religion. I know this doesn't specifically pertain to transgender rights, but it's a real important thing, and that's with our foster care system. The way it works in Michigan is Michigan contracts with private agencies to provide foster care services. And some of those agencies are faith-based agencies. And so when these agencies get a contract with the state, they're essentially agents of the state. They're paid with taxpayer-funded dollars, and they're acting on behalf of the state. And in the past, there have been some faith-based agencies that have refused to work with same-sex couples. In other words, they won't license them for foster care, and based on their religious belief. And we filed a lawsuit against the state of Michigan in 2017 because the state was allowing this practice to go on. And we felt that it was not only discriminatory, but also it violated separation of church and state on behalf of the government, since these were government agencies. And even more importantly, we felt that it had a negative impact on children who are in need of a loving and supportive home, including transgender kids who might be in the foster care system. And we were able to reach a settlement with the state of Michigan last year with a new administration, with a new attorney general. And that settlement agreement has been attacked in federal court in two separate lawsuits at this point in time. One that was brought by St. Vincent Catholic Charities in the Western District, and another lawsuit that was brought by Catholic Charities of Southwestern Michigan. They're arguing that by requiring them to have to adhere to non-discriminatory criteria in a state contract, that violates their religious freedom. And in the St. Vincent Catholic Charities case, the judge agreed with St. Vincent and issued a preliminary injunction. In other words, telling the state that you couldn't enforce the non-discrimination language in their contract. Now that case is on appeal. What does this all mean? Why is it so important? Because if we develop case law that says you can't discriminate against people except LGBT people, even with government contracts, then we are sanctioning discrimination against the community. And we are allowing discrimination with taxpayer funds based on a particular religious viewpoint. And that's a very, very dangerous, slippery slope. And the reason I bring that up because that's another essential tactic of opponents of LGBT rights to try to use religion as a basis and a justification for discrimination. So that's my updates at this point in time. And I wanted to see if anybody might have any questions, specific questions about anything related to transgender rights and policies and procedures that I can answer. Feel free to send a message. Well, I don't see any questions right now, but I want to remind people, the ACLU, we may be working remotely, but we are still open for business. I'm still open for business. And if anybody has any questions or issues that come up during this period, once again, my phone number is 313-578-6812. You'll get my voicemail, but all the calls are sent to me, and I will call you back. And my email, you can send me an email. It's Kaplan, Kaplan, at ACLUMICH.org. Okay, we have a question. My daughter, age 20, has had gender confirmation surgery and had gender marker change on her birth certificate. Let me just open the full question. Can that be revoked if the laws change? Is there a way to seal her original birth certificate now that she is adult? Would that be a good thing to do? Okay, so Michigan's, the way our policy works for gender marker change on a birth certificate, it's by statute. And we need to change that statute because it requires that you have to have undergone gender reassignment surgery in order to get that change. There's not a specific procedure that's required, but we do know that that not everybody has surgery, and that surgery is not the sole indicative factor of one's gender identity. So if she was able to get a gender marker change on her birth certificate, no statute could undo that. No statute could take that away. So I don't think we're in danger of doing anything like that. And actually, like I said, what we want to do is we want to eliminate that surgery requirement in our statute for birth certificate gender marker changes. And legislation has been introduced that would do that. But once again, we're up against the same problem. The legislative leadership will not move these bills forward. And we have to continue advocating for them to do so. Is there a way to seal the original birth certificate now that she is an adult? I believe that you, under certain circumstances, I think if someone went through an adoption, you can have the birth certificate sealed. But what happens is when you get a gender marker change, and if that also involves a legal name change on your birth certificate, they're going to issue you a new birth certificate. And that's the document that's going to be used, and that's the record that you're going to have. Do we know when the Williamston case might be decided? We do not know. It's been interesting. This case was filed more than 2 years ago. And other than the judge permitting us to intervene in the lawsuit, he's made no decisions on anything else at this point in time. We filed a motion, and the school district also filed a motion to dismiss the case. And no hearing has been scheduled on that. And I guess that's a good thing, because we kind of think that it's a meritless lawsuit. And as far as, no news on that case is probably good news. Let's see if there's any other questions. Right. So just a reminder, people are asking about sealing the birth certificate. When you get your gender marker change and a name change on your birth certificate, the original birth certificate is not sealed. They don't seal it based on that basis. But no one should really have access to that except within the Department of Vital Records. That is also something we should look into, though, in terms of a legislative change to, to the current law, because I know that people, really value their privacy, and it's important that that information is protected for them. Any other questions that people might have? All right. I just want to thank everybody for joining, and but you can request it sealed. Okay, Roz is educating me more on this birth certificate than I knew. Okay, so it's not. So let me just make sure, because I obviously I am not an expert on birth certificates, but when you get a gender marker change and a name change on your Michigan birth certificate, they don't automatically seal the old birth certificate, but you can request that it be sealed. Are you aware of school districts who have hate speech acts policies that are inclusive of LGBTQ students? Wondering if our school district works towards that and they're challenged on religious grounds, if it will stand. Well, there's a number of school districts that have anti-bullying policies that specifically, mention sexual orientation and gender identity. There was a case involving the Howell School District where a family challenged that in federal court, saying that it violated their religious freedoms, and that particular claim was dismissed. It wasn't valid. Once again, people are entitled to their religious beliefs, but it doesn't mean that they necessarily have a veto over a school district policy that wants to promote fairness or safety of other students. In these particular cases, usually the plaintiffs are unable, they haven't been able to allege how having such a policy interferes with their religious beliefs. And with regards to bullying or harassment, it's pretty unlikely that a particular religious principle would advocate for physical violence or verbal harassment against a student who might be LGBT. With regards to policies concerning speech, I think it's good. School districts have to be very, very careful how they tread that line and decide what's acceptable speech and what's not acceptable speech, because students do have First Amendment rights. They have a right to offer their opinion about something in a classroom discussion. They have a right to talk about a particular topic that's germane to what's being studied at school, but they certainly don't have a right to threaten a student with violence. They don't necessarily have a right to harass a student, to interfere with that student's ability to learn. And so what we've found that's probably the most important thing that a school district can do is to provide training to both staff and students about what bullying means, and what types of conduct is permitted and what type of conduct is not permitted. I think for many years, by not talking about, by not acknowledging the fact that you have LGBT students in your school, it kind of creates this elephant in the room, and if what you don't talk about, you don't necessarily recognize as a form of bullying. And we find even today, with GLSEN does a climate study of schools, and they find that often harassment of LGBT kids occurs in front of staff, and sometimes it's that the staff don't even recognize that as a form of bullying. So it's great to have a policy on paper, but even more important, you need to have the training and the education of both students and staff about what you need to do. And Stand With Trans is available to do trainings for school districts and to explain to them, not only just the basics about what it means to be transgender, but also to help them recognize when bullying and harassment occurs and things that they can do to effectively address that. Anything else? I forgot this was called a happy hour. I have my cup of water this afternoon. We'll wait a second and see if there's any other questions. Okay, then. Well, thank you very much, everyone, and stay safe and stay healthy, and contact us if any questions or problems come up.